Hello, good morning. This is Dr. Iftikhar Ahmed Ansari, Department of Political Science, Aligarh Muslim University. Today I am going to talk about rights, and this is going to be my second presentation on the topic. And today I am going to talk about the theories of rights and different perspectives of right. Now, the very first thing that comes to our mind, like when we say rights and different theories, then what are the bases? What are the bases on which these rights should be given to men in society? Now, that brings into question the various theories and its suitability that can be founded or that can lay the foundation for rights in society. So, there is no commonly acceptable answer to this question, like on what basis a man should get the rights. So many questions have been raised and many answers have been provided in the last 300 years. And the first time when the demand for the personal right was raised, first of all by the middle class in that century, 17th century, which came in existence due to the result of the Industrial Revolution. Now, this was the fundamental question of the revolutionaries of America and France, which was later on answered by coming into existence of Bills of Rights of America and Declaration of Rights of Man in France. Now, since the time of the beginner, the scholars like Locke, then Rousseau, Bentham, J.S. Mill, T.H. Green, Lasky, Barker, etc., they have considered the demand for the rights to be right. Now, after the Second World War, the development of the concept of the right was done through the writings of Rawls, Nozick, and Dworkin, etc. So, various rights have been justified on various bases. We knew all the bases of these theories, and some of the important theories and perspectives are today we are going to discuss and understand. Now, the first in that direction is theory of natural rights, and this theory it postulates that rights are not granted by the state, but they come from the very nature of man, his own intrinsic being. Now, this theory was broadly developed on two important bases, that is a contractual base and the teleological base. Now, the contractual base, it talks about certain rights which were enjoyed by the man in the state of nature. Now, that state of nature was hypothetical in character, and that was the formation of civil society itself before the formation of state. So, these comprises the natural rights of the man, which must be respected and protected by the state. However, after the formation of the state through contract, Hobbes and Rousseau believed that the man surrendered their natural rights as the price of civil rights. In fact, both Hobbes and Rousseau do not think that natural rights would be maintained by the state. Locke, however, on the other hand, postulates that man surrendered only some of his natural rights, particularly the right to be the judge of his own act, on the condition that his fundamental and natural rights, that is the right to life, liberty and property, shall be protected by the state. Now, if the state failed to maintain these rights, then men have a right to overthrow that government and set up a new government in its place. Now, thus for his natural rights could be the basis of the government of the state. That is what this theory says. Now, another aspect of this theory is teleological base. Now, teleological means the doctrine of final causes, that it signifies the view that any development are due to the purpose or design that it served by them. So, teleological view of right therefore seeks to relate the right of man with the purpose of human right. Now, Tom Paine in his Right of Man in 1791 elucidated the theory of natural rights on teleological basis. He affirms that every generation is free to act as per its understanding of the situation, but rights to liberty, property, security, resistance of oppression, now these are something which are very inherent, and man is a proud possession of these rights, which are the civil rights, and it drives the sanction of these rights from the natural state where he was living. So, it is pre-existing in the individual itself. Now, second intellectual who talked about this teleological basis is T.H. Green. He also sought to build his theory of moral rights on the teleological basis. Green argues that the rights of man do not emanate from any transcendental law, as Locke had maintained, but they come from the moral character of man himself. So each individual, impelled by his moral consciousness, tends to seek ideal objects. Now, since all individuals share the same moral consciousness, their ideal objects are common objects. So, natural rights are claimed to be eternal and immutable, but in actual practice, they are capable of immense variations. Now, Aristotle saw slavery as natural. Now, can this law or can this understanding or teleological end of the state, can this be accepted as a right? So, this view no longer upheld, and some people treat it as naturally superior to women, others treat it as equal by nature. Now, this again is something which cannot be given in present society. So, right to property was for long treated as a natural right, but this view was radically modified under the influence of socialist thought. So, in thought, the concept of natural rights is a subjective concept, and this cannot be the basis of rights because it keeps on changing as the individual perceives the right to be. Now, the second right, theory of right, is legal right. So, no rights are absolute, nor are any rights inherent in nature of man as such. That is what this theory believes, and rights are relative to law of the land. Hence, they vary with time and space. Rights have no substance until they are guaranteed by state. That is what this theory confirms, and this implies that in the first place there are no rights prior to the state because they came into existence with the arrival of the state itself. And secondly, it is the state which declares the law, whereby guaranteeing that it will be enforced. So, no right can exist beyond the legal framework provided by the state. And finally, as the law may change from time to time, so substance of right also changes with it. So, there are no fixed rights in any society, nor to speak of any eternal or universal or immutable rights. So, Jamin Bentham, he condemned these natural rights as an invention of some fantasy, which are dogmatic and unintelligible to a modern mind and devoid of any reasoning at all. So, it is thus evident that the theory of legal rights was advanced with a focus on political reality and to repudiate the imaginative character of natural rights theory. Now, this theory does not tell us whether the rights are recognized, which the state recognizes, are the rights which need to be recognized. Now, in other words, the theory of legal rights take account of the factual position only. It takes note of what rights are legally recognized and guaranteed in a particular state. And political philosophy would like to inquire as to what rights must be recognized by the state according to the community's perception of justice. It does not tell what rights of men are essential for the fulfillment of the social purpose of human personality. So, rights are conceived by the community through its moral consciousness. So, steps must be taken to secure legal sanctions for those rights only which have the moral basis, and which otherwise these rights will remain simply the empty promises. Now, the third theory of right is that of historical rights. Now, historical theory of rights, it holds that rights are the product of long historical process. So, rights grow out of custom which stabilize through usage in several generations. It upholds and defended the evolutionary change, and it discourages the revolution. So, at best, these adherents of theory, they believe in a revolution, that too a revolution which has come in a slow manner or which changes without any radical change or without any bloodshed. So, Edmund Burke, the greatest champion of historical theory of rights, criticized the French Revolution, for it was provoked by a conception of abstract rights of man, that is liberty, equality and fraternity. On the contrary, he glorified the English Revolution of 1688, which sought to reassert the customary rights that Englishmen had enjoyed from very early days and which had found expression in such documents as Magna Carta and Petition of Rights. So, historical theory of rights is an important contribution in the list of theories of rights, because it suggests that the state cannot create rights as its own will, nor it is required to follow any abstract or subjective conceptions of natural rights. So, the state has only to recognize those rights of men which have already come into vogue through long standing usage and custom. But the difficulty with this theory is that it does not provide for any criteria to ensure that rights are based on a sense of justice. So many customs evolved through long historical process involve injustice and oppression of some vulnerable sections of society, like we have earlier we had sati pratha. So, and many more such practices which were against or detrimental to the interest of women. So, they cannot be held as a historical right and approved by the state itself. Then next theory of rights is social welfare theory of rights, and this theory postulates that rights are in essence, these are the conditions of social welfare. So the rights, it believes that the society should set aside all other considerations and recognize only such rights as are designed to promote social welfare. So, the utilitarian school of 19th century led by Bentham postulated the greatest happiness of the greatest number as the sole criterion of legislation and recognition of rights. State should yield to what is socially useful or socially expedient. Rights should be determined by balance of interest under the prevailing social conditions. So, among the contemporary advocates of social welfare theory, Roscoe Pound and Zachariah Kaifi are most outstanding, and social welfare theory seems to be quite reasonable, because no theory of right can be held valid till it serves the cause of social justice. So, this theory eliminates the subjective, ambiguous, dogmatic and static or static nature or criteria. But again, this theory presents practical difficulties. The question is, who will define social welfare or social expediency? Now, usually it is an elite, a group of chosen few. So, who assume the power to interpret the requirements of social welfare. So, Bentham's formula of the greatest happiness of the greatest number was in effect invoked to create rights situated to a free market society, which resulted in oppression of the huge mass of working class. So, this theory does not hold much water. Next theory is the social democratic perspective. Now, social democratic perspective on the rights seeks to achieve the objective of individual liberty and social justice together. So, these are certain perspectives which provide an alternative to the theories which can be the basis of rights in society. Now, it is best represented by Lasky's theory of rights, and Lasky has thoroughly investigated the moral foundation of rights, which postulates a synthesis of liberal and socialist values within a democratic structure. Now, in the event he has evolved a theory of service state and produced a rather elaborate blueprint of a just society. Now, when he is talking about social democratic perspective, he is talking of synthesis of liberal and socialist values. So, Lasky has strongly argued that liberty, which is the essence of rights, is neither perfectly secured in a capitalist democracy like America, nor in a socialist dictatorship like Russia. So, it is the rigidness of the two systems which are responsible for the crushing one or the other vital aspect of the individual liberty. So, Lasky therefore pleads for establishing a service state where industrial production is undertaken in order to meet the social needs, not the private profit. Then it also has a moral foundation. According to this perspective, T.H. Green, he erected his theory of rights on moral foundation, and here Lasky is providing again a different moral condition when he says he is much ahead of Green in dealing with the maladies of the capitalist system. Lasky holds the rights are not concessions granted by the state. On the contrary, they are superior to the state itself, because the moral basis of right postulates equal treatment of all citizens in matter of securing their rights. So, Lasky admits the differentiation of rights according to the functions which they come to perform, provided that the elementary needs of each individual has been satisfied. So, the moral authority of the state as it claims to allegiance, is based on its devotion to the common good and its recognition of the claims of personality. So, Lasky's theory of rights takes three different aspects into consideration: interest of the individual, interest of various groups through which his personality finds the channels of expression, and the interest of community, which is the total result of the combined pressure of the social forces. So, the individuals, and for that matter social groups, cannot be left to define their own rights in conflicting manners. So, it is the instrumentality of the state which resolves their conflicts and regulates the behavior of individual and groups by common rules. So, but the question again remains, who will tame the manipulator of power? Now, will they just be prepared to relinquish their privileged position on some fascinating prescription of an expert political scientist? How can a substantive political change be effected without strong pressure from the oppressed class themselves? So, Lasky's scheme needs to pass the test of political reality to be the real basis of rights in society. Now, another perspective that can be provided to uphold rights in society is that of Marxist perspective. Although Marxists themselves has provided no such theory of right as such, but the exponents of Marxism, they have analyzed the principle of freedom, equality and justice as the basis of social organization, and not with a reference to their implication as the rights of man. So, in practice, however, socialist states have evolved elaborate scheme of rights which can be discussed in the context of this Marxist theory of rights. Now, their concept of right, when we talk about it, is in contrast to the liberal individualistic rights ranging from freedom of trade, freedom of contract, or freedom of thought, expression, or right to vote. Now, this all had, according to the Marxists, they had no substantive advantage for the common man so long as the society is divided into antagonistic classes, and these antagonistic classes, they have opposite interest. So, whether they are dominant or dependent, oppressor, oppressed, exploiter, exploited, so they are antagonistic in nature, their relation. So, on the other hand, Marxist theory sought to secure the freedom of man from these conditions of injustice and exploitation, and it insisted on the sociable nature of man, which will ensure rights for them. So, rights under socialist system, which will be the governing principle of communist society, will be from each according to its ability to each according to his need. Now, that was the guiding principle of all the rights. So, the citizens of erstwhile USSR were guaranteed not only equality before law, but also equal right in all spheres of economic, political, social and cultural life. Above all, they were entitled to the right to work, that is guaranteed employment and pay in accordance with the quality and quantity of work, and not below the not below the subsistence level, and establishing some kind of minimum pay scale. So, including the right to choose their trade and profession as well. But what we saw in actual practice was just opposite to that, and it was also told that they were all these rights will be allowed only when state has withered away and socialist society is formed. As long as socialism is in ascendancy and trying to spread all over the world, these rights cannot be enjoyed. So, it guaranteed in fact nothing, although promising a great promise. Now, if we look at another perspective which is more modern in nature and which is a multicultural perspective on rights. Now, according to this view, the accommodation of differences is the essence of true equality, and group specific rights are needed to accommodate differences. Now, proponents of individual rights, they respond saying that individual rights already allow for the accommodation of differences, and that true equality requires equal rights for each individual regardless of race or ethnicity. But some minority rights are eliminated rather than created in inequalities. Some groups are unfairly disadvantaged in the cultural marketplace, and the political recognition and support can rectify this disadvantage. So, their societal culture may be undermined by economic and political decisions made by the majority, and they could be outbid or outvoted on resources and policies that are crucial for the survival of their societal culture. So, the members of majority culture do not face this problem given the importance of cultural membership. Now, this is a significant inequality which becomes a serious injustice if it is not addressed adequately in a society. So, the theory of right which multicultural perspective presents, it recognizes the fairness of protection for the minorities. Giving minority rights to members of minority cultures may eliminate certain disadvantages faced by them, like group differentiated rights such as territorial autonomy or veto powers or guaranteed representation or land claims or language rights. Now, these can help rectify these advantages by alleviating the vulnerability of this minority culture to majority decisions. Although this multicultural perspective has found many supporters, there are problems within it regarding the women's right, since most cultures endorse and permit the control over women by men, and also multiculturalism would pose a challenge to the liberal notion of nation state. That is, it may lead to secessionist movements like the one we have already in present reality in Kashmir or northeast India or in Tamils in Sri Lanka, etc. So, as Bhikkhu Parekh asserts, in multicultural societies, cultural communities generally demand various kinds of rights. They need to maintain their identity. Now, some of these rights, usually called the group, collective or communal, are not easy to accommodate within a liberal jurisprudence and raise difficult questions such as whether the concept of collective rights is logically coherent, or what kind of rights, just as individual rights are those rights of which the individuals are the bearers, the collective rights are those of which the human collectives are the bearers. So, these questions remain, and in contemporary world, the scope of right needs to be expanded further, and the problem of protecting the life and health in the present day society has become more complex. So, the spread of such activities like terrorism or drug trafficking or environmental pollutions, they are now the major threats posed to humanity in different societies. So, it is the duty of state to save the people from these threats. Now, this duty of the state must be included in the list of human rights, which is a latest perspective, rights having a human nature. So, whereas the supports and the efforts of the nation states might have been sufficient to protect the traditional human rights, the new human right can be maintained only through the global effort at the global level by countering such menace for the society in the form of terrorism, drug trafficking, environmental pollution, which is threatening the all rights of individual, whether civil or political or economic or religious or cultural rights. So, with that I come to the end of my presentation for today on rights, that is the theories of rights, and also talking about different perspectives which can support or provide alternative to the concept of and theories of rights. Thank you.